Olivia, James, Phil, kia ora. That's a lot of work, and I know how fast this is all changing, and lots of surprises as well through the process. So thank you for bringing this to us, and I'll hand over to you to take us through it. Thank you.
Kia ora koutou. Thank you, Chair Pauling. So we have a team here today. We've got representation from our consent section with Phil Burge and from our compliance and enforcement section from James Tricker. And plan today is to run through the presentation. I'll talk about the front piece and hand it to the experts here around the consenting and compliance space. We'll move through reasonably quickly so you have enough time for questions, and we might just start straight into it. So briefing today is on the Resource Management and Other Changes Amendment Act and other system changes. What we will go through is what's on the slide today, so those changes to the system, particularly the macro level impacts and implications with direct impacts for our regulatory functions and our active court cases, and then just finish up with that implementation update. Just note the Ministry is obviously responsible for implementation of the system. It's their legislation, but they're doing things as well to support that pathway through. I just want to start with situating the conversation today. So you will have seen this slide several times before, but each time we talk to you about resource management reform, we put it back up there, principally because things change, and I just want to talk about a couple of things that are changing in that space. So today's conversation is in the context of the Phase 2 program. So we're talking about RMA Act number 2. What's happened at the moment is we've also got that national direction package that's also moving through the system, and Council put a submission in on that. Just want to provide you an update in that space. So where the Ministry's at the moment is they've had 21,000 submissions on the freshwater proposals and around 600 on the primary sector and infrastructure proposals, so big difference there. And the officials are providing the advice to ministers, and we should expect some further decisions from ministers in September, and cabinet decisions to follow. And then we're expecting a round of consultation on an exposure draft and NES, and that's likely to happen next year. Now, the interplay between that and what I'm talking to you today about particularly relates around the ministerial powers. So one of the powers I'll talk to you about is the power for the minister to amend or to direct a local authority to amend its planning instruments to implement a new MPS. I would expect that we would see that national direction package move through the system first before the minister would consider the use of those powers. Now, obviously, I don't know that, but that would seem to be the reasonable approach. And then, obviously, we've got the Phase 3 package at the end of the year, and further changes to come.
Can I ask, I don't want to butt in, but can I ask, in terms of those ministerial powers that have been looked at, is that on application by a body, or can anyone just apply to the minister to have something changed?
Peter, it's the minister telling us what to do. It's not.
My point being that the minister must be alerted it through some mechanism. The minister's got a lot to do, as he told Dion.
I think that still exists, though. But we'll get to it. There is a bit of that in this presentation too, so we'll get to that partway through. So let's carry on.
Yeah. So just summary. So. As I mentioned, this is the Resource Management Consenting and Other System Changes Act. It passed into law on the 20th of August, and we were expecting changes to actually commence in September. That was the advice from the Ministry. We'd have a little bit of transition time. What actually happened is that it took effect the next day. So that's meant we've had to move really, really quickly on this, including doing a rapid assessment for you guys and looking at what those changes mean for our regulatory functions, and we should expect that going forward. Things will change quickly. And just to be aware, while they call this the Consenting and Other System Changes Act, it actually touches on everything pretty much that can affect local government in the RMA space. So, yeah. And then alongside that, we've also had the changes to resource management infringement punishment and offences regulations. So those are regulations that sit under the Act, secondary legislation, principally around increasing penalties, expanding some offences, and tomorrow James will talk more about those in his section, but generally have implications for cost recovery, issuing of abatement notices, etc. And councillors would have seen this slide also before, and the reason I've put it up again is that when we first presented this slide to you, what we were indicating is that there are a number of changes coming from central government at the top of the system, but the impacts are borne by a regional government. And at the time, we pulled this together effectively based on a bit of intelligence and horizon scanning, what we see out there based on what we were hearing, what we were seeing, and some of the legislation coming through. And it very much is that we're seeing those effects realised now. And so looking forward, the chat and conversation that we hear out there around the RM system, we need to keep listening to, because it is materialising as it's sort of being played out. So next two slides are really a summary of key changes, and I was going to say ministers, councillors will have received this information earlier when we provided our fact sheet to you. The thing I want to kind of point out on these two slides is the difference in terms of powers and restrictions. What we are seeing at the moment is an expansion of ministerial powers, and as a consequence, a contraction of local government powers. And while there's ministerial powers in planning, you can actually think of that as ministerial powers and governance powers for local government. The two changes that have come through, which are in red, have happened after the select committee process, are the power for the minister to make regulations, to remove council plan provisions where they impact on economic growth, development capacity or employment. That's obviously critical in the context of regional council functions. And secondly, that a new power around the ability to restrict councils from notifying policy statements or plans, and Minister Bishop signalled that very clearly at the local government conference. The one that's not in red, but arguably could be, is the one on the bottom, which talks about regional plans including permitted activity rules for discharges, because there have been changes in that space too, although that was signalled as part of the bill.
Be keen to carry on, sorry, Claire, but you'll be first up when we get to the questions.
Just in terms of the flip side of this, so what we're actually seeing in the consenting and the compliance and enforcement space is probably more tools or more powers available to regional councils to exercise their statutory functions. So contraction in one space, in the governance space, but expansion around tools and powers in the consenting and compliance. And again, when I go through this, we can come back to any detail later if you've got questions on it. And just to situate this conversation, one of the things we do when we are looking at our sort of rapid assessment is to think about what council's drivers are. So in the context of the strategic direction in your position statements, obviously they're informing and guiding the development of your policies and your approach. But in the context of this, where you are an implementer of legislation, it's really thinking about those 4 PO and how we respond to this change, because you have choices about how you respond and adapt. So that's how we like to look at this when we're thinking about how to prepare for implementing the changes. So we're going to talk a little bit now about some of the high-level impacts and implications, and also opportunities, because there are opportunities. But I think the first one is obviously in that governance space. So as your powers to make decisions as elected members become constrained, there is a risk now that your ability to make those decisions in the interests of your communities are impacted. And if we think about regional councils a little bit, I would say almost like the meat in the sandwich, we have community outcomes and expectations that are rising. You have the restrictions on your powers at the top of the system contracting, and it's becoming a more challenging space, I would say, to work in there. In terms of partnership, so one of the changes is that change to give the minister the power to restrict notification of new plan changes, and they've done that. And for this council, plan changes are one of the key tools that we have used in the past to deliver on mana whenua aspirations and outcomes. And what this means is that if we want to continue that journey, we really need to be thinking about what are the other tools we can use so we are less vulnerable to the impacts of that legislative change. And that might be non-regulatory mechanisms, it might be initiatives that we develop in partnership, but thinking more broadly. Also, I'd like to just note that one of the things that the Council's been particularly proactive about is putting in place plan provisions to protect things like wahi tapu and wahi tonga. And if we think about those other powers that allow provisions to be removed or amended, we need to be thinking about what the potential consequences there are to make sure we provide protection going forward. And then lastly, on the outcomes space, the particular restriction around amending provisions where they impact on economic growth, that's a consequence we need to be very mindful of, given we have plans in place with limits to manage the environmental impacts of growth. And so if we are thinking about which local authorities might be impacted by this significantly, it's more likely, I would say, to be a regional council than a territorial authority, just given the nature of the different functions in that space. So unitaries are their own. They have a rather... No, they are, yep. So this power applies broadly, but yeah, they would be impacted the same, yeah. In terms of funding, so one of the implications to be aware of is that the Minister can now direct a local authority to initiate a plan change to implement a national policy statement. We will bear the cost of that, and the Minister gets to choose whichever planning process they deem fit. You might think that they might choose to use something like a streamlined planning process to minimise costs to a council, but interestingly, now councils have the decision-making power around approving streamlined planning processes. If they wanted to amend a plan change, they might not use that one because they might not get the outcome they want. So there will be a cost impact there. And then lastly, in terms of commitments and statutory responsibilities, I think the statutory responsibility one is one to bear in mind. We have particular functions under Section 30 of the Act relating to maintenance and enhancement of the natural environment. As those powers start to be brought to bear to change plans to enable growth, that might put us at risk of not being able to deliver on those functions, and then that can lead to further statutory interventions by government if they deem it fit. Now, I don't want this to be sounding as though this is all negative. I'm just trying to highlight the potential risks that we're seeing in that space so we can make some good decisions moving forward. And as I said, there are some really good opportunities in this space too. So the cost recovery provision, which is something the Council supported in their submission, provides us a new tool. We can cost recover in relation to incident response work or complaints where we've been satisfied that an offence has been committed. We have some cost recovery provisions around, or powers around, permitted activity monitoring. Although one of the things for this council to be aware of is that we can't cost recover for permitted activity monitoring where it's a rule is the same as in a national environmental standard. The reason I mention that is simply because a lot of our rules are quite similar to what we've seen through national environmental standards because we've been leading that space. But yes, it does provide us some new powers and some tools, which is positive. The new provisions around sort of consent processing, they're positive for us to be able to deliver on our sustainable consents delivery program in terms of processing timeframes and returning applications. And also, I think in that environmental outcomes space, that shift towards disincentivising poor environmental performance through things such as penalties or past compliance history is positive. And we'll be looking at that in terms of the Smart Enabling Regulator program, which I know the Council is receiving a briefing on coming up. So in terms of active court cases, so one of the changes that has been made is to Section 70 of the RMA, and that was a change that the government introduced in response to a number of court cases around the country. So a challenge in Waikato on Plan Change 1, a challenge in Southland around their permitted activity rules, and a challenge in Canterbury around permitted activity rules in our plan. What the new provisions in Section 70 allow is that you can have a permitted activity rule in your plan to manage those discharges, provided those effects already exist in the receiving waters. You have standards in your rules, so that might be standards on the quality of the discharge or the duration of it, and that you can demonstrate, probably through your Section 32 report, that overall there'll be a reduction in effects over time and within 10 years that you can demonstrate that. The two things that have happened since the public consultation process are that we've seen the range of effects that you can have permitted activity rules for has been expanded. So now you can have a permitted activity rule that allows for management of activities not just where they give rise to significant adverse effects on aquatic life, but also where they result in changes in clarity and water colour, and also where they would give rise to effects that would render water not suitable for consumption by farm animals. The reason that those changes came in were principally in response to some plan changes that are being challenged in Waikato, and so that's come in. And then significantly, one of the changes that came in through an amendment paper concerned the application of those provisions. So those new Section 70 provisions apply to rules and proposed plan, and that becomes very significant in the context of our current court case, which I'll talk to on the next slide. But I'll take a drink of water first. So, as Council will be aware, there is an active judicial review of Rule 5.63 of the Canterbury Land and Water Regional Plan. That rule is an operative permitted activity rule, and it authorises those incidental discharges of nutrients from farming activities. The Environmental Law Initiative were the party that challenged the decision for us to include that rule. They challenged our decision-making process, and significantly they asked the court to quash the rule. That's the relief they have sought. So we have had a hearing and a decision is pending, and I just want to take the moment to make the point that you will have seen in the media a decision from the High Court in relation to another judicial review with Canterbury. This is not the case that I'm talking about here. That case relates to a consent granted to MHV for discharging nutrients. So these are separate cases. So we are still waiting for the High Court's decision on this one. And really, we won't know what the implications of these Section 70 changes are until we receive that High Court decision. But we are thinking about and anticipating what the outcomes are, and we will be doing some further work in that space, which I'll talk to coming up. So just to contextualise what the High Court might land with, we could see three possible outcomes. We could see the court rule in our favour, in which case our rule stands, and all those farming activities that are currently permitted by that rule would continue to be permitted. We could find that the High Court rules in ELI's favour, and they refer the rule back to us to reconsider, in which case the council then has to go through that decision-making process again, and it would apply the new provisions in Section 70 when it looks at that rule. And likely what would happen is that there may have to be a panel stood up to reconsider the rule. We've had that happen in the past on land and water plan challenges right at the start, so that's one possible outcome. The third possible outcome, of course, is that the High Court grants ELI the relief to quash the rule. Now, if that happens, we have 4,500 farmers still requiring resource consent, and the changes that have come through Section 70 don't resolve that issue. We would still have that situation, and farmers would be required to get consent. There would be cost associated with that, and their discharges, if they don't get that consent, would remain unlawful. There's a cost impact to us as a council if we can't meet our statutory processing timeframes as well. So, as I said, the issue for us is there's that amendment to the Act to say that those provisions only apply to proposed permitted activity rules, whereas we have an operative rule. and that's where the challenge has been created. So a lot of other councils are in a reasonably good position, but it's not the case for us. Having talked briefly to our lawyers, they said that the fact that this piece has been changed probably doesn't really bind the court anyway. So we were possibly always going to be facing this outcome, but it's now become more apparent with this very explicit wording. And so we are looking at some options. I don't want to provide too much information at the moment until we've thought through the options, but I will say that some of the new powers that the Minister has to be able to change plans and amend them might be options that are available to us, but we need to go through that process of pulling together an analysis of what's available to you in the event that one of those two things arises. And of course, we might get the outcome that we want. We have a favourable outcome on the other court case. I think one positive thing here is that there's 3 limbs to the council's defence on this, and we only have to prove one. So there's 3 possible ways for success. And so lastly, before I'm going to hand over to Phil to talk through some consenting matters, and happy whether we want to pause there or just be guided by you, Chair, is just the changes around restrictions on notification of regional policy statements and plans. There are 2 pathways available for an exemption. So an exemption is available. So there's automatic exemptions for addressing natural hazards, giving effect to treaty settlements, and giving effect to the intensification provisions. The council makes the decision on that, but any of those decisions can be judicially reviewed, of course. And then there's an exemption pathway through an application to the Minister, and that's a much broader range of exemption criteria and circumstances. We would have to go through a process of making an application if we wanted to progress a plan change, and that decision's made by the Minister. What I would say on that is I expect that to be a very, very busy time for the Minister. I've had a chat to other regional councils who are looking at this. Around half of them are thinking around making an application to the Minister, and then we have 67 territorial authorities who might be considering that too. So I'm not sure that it will be necessarily quick, and it will depend on the Minister's priorities as well. And so in terms of planning implications, we've already talked to you about the plan stop announcement, and you made the decision to pause the regional policy statement notification. And at that time, we had Plan Change 8, which was moving through the process. And just recently, the team's informed me that the pre-notification consultation on Plan Change 8 has been completed, and they're going to be looking to brief you on the outcomes of that consultation as soon as we're able to get in front of you. But to progress it, 2 things have to happen. One, we have to get an exemption from the Minister, and then you would have to make the decision to notify. We've just had word from the Ministry staff that the Plan Change 8 likely meets the criteria for exemption. And if I go back to the previous slide, the exemption criteria that it meets would be that it would rectify provisions that have unintended consequences possibly, and also enables work to be progressed by that the Minister considers appropriate. Particularly we're thinking about those impacts on stormwater management and those sort of aspects. So I can stop there, or we can move on to consenting compliance.
Yeah, I mean, it's been quite a lot of information, and I know I've got 2 questions, but I don't want to take too much longer. So if it's about consents and compliance, we'll wait till we hear from Phil and James, but I think we can ask Claire's question and Genevieve's question and maybe 2 others. There we go. Claire?
Thank you.
Mike? Yep.
Thank you very much for the presentation in the paper. Just with regard to the impacts and the implications that you've pulled out, and obviously as if you've gone on and said, well, actually, there's some things in there that we might be able to use. My understanding is, God forbid I spent time looking at the bill last night, that the plan changes and the ministerial powers to modify those plans are temporary till 2020 or the end of 2027. Basically. So basically it's nothing well, my reading of it is it's really not much different to what we've already been told, is it?
With the exception of that amending and modifying plan provisions, the ability to create regulations, that was one that wasn't signalled before. Yeah, and you're quite right. It's only till the end of December 2027. What we do know is that government has also signalled that these changes are intended to lay the foundation for phase 3 reform. So whether or not those powers carry over, not sure. Yeah.
Thanks, Claire. Genevieve?
Thanks for your briefing. It's all pretty disturbing, to be honest. But just with regards to, you discussed Section 70, but there's no discussion about the Section 107 implementational changes that was requested. So do we have any update on that and how that might apply under the Section 70 discharges to coastal? Sorry.
So the Section 107 changes were progressed through that earlier Amendment Act, RM Bill number 1, so they are law now. So they have been law for quite a bit of time, and this is effectively the mirror of those Section 107 changes into Section 70, one applying to consenting and one applying to plan making. So the reason they're not on here is simply because they were part of the last set of amendments.
I guess my sort of confusion is, or just to clarify, that some of our rules and our plans brought in the whole intention of Section 70 to actually get those rules in place, and they were assessed at the time of implementing the rules. So how does that apply to the whole land and water plan? I find it really quite concerning that the intention of Section 70 applies right throughout. So yeah.
I might not have got the question quite right, but in terms of so the Section 107 changes that we're implementing now, our consents team are applying that expanded range of criteria when they're considering consents. The Section 70 changes are relevant in the context of making the plan and implementing that plan intent. And the Council's position on the Section 70 change, particularly in the High Court case, is that we demonstrated through that process that we have satisfied the criteria when making those plans and giving an effect to those outcomes. And so I might not have picked up the question quite right.
Yeah, you're right. But I just guess, though, that knowing that it is threaded throughout those rules, if there's changes to the actual section, does that affect the effectiveness of the rules? That's what I'm trying to say.
No, it doesn't affect the effectiveness of the rules. And the way I would think about it is that Section 70 set out necessary tests that we must pass through when making our plans. But when we make plans, we're not just looking to satisfy the tests, we're looking to achieve community outcomes around sort of water quality, etc. And the changes that are made to Section 70 don't change the application of the rules that we have in place at the moment. So even though there's broadening to allow us to have, rules in place to manage, that could potentially be considered weakened, the rules in place aren't affected by that.
Thanks, Genevieve. Jan, and then Nook, Peter, and Ian, and that's it. We'll move on. There'll be a chance at the end for more.
Kia ora koutou. Taking the words from one of my fellow councillors, I am challenged. I'm challenged by what you've just said. I mean that is like, especially in regards to partnership. Talking about mana whenua, and then what could happen with change, ability to by the provisions of the minister to pause or change plans, but also if you kind of look at it, the community agreed outcomes, and then if the minister doesn't agree with it, just come in and stop it or change it. So that's kind of a little bit scary. So I suppose it's anyway. So alternative tools. So what could some of those be in a sense that can't be challenged or changed by the minister?
So I think anything that sits outside the regulatory sphere, non-statutory stuff. Of course, the constraint that comes on us if we're thinking about the future system is obviously we will have rates caps potentially applying. So it's about looking for those opportunities where you can use those broader tools within the financial constraints that are put on this council in the future. But, if we think about some of the things that things like whakaora, healthy harbours sort of programs, some of the good work that we've been doing around sort of the wetland construction and things like that. There are opportunities. It's just we've got to think a little broadly, I think, and more broadly now. Yeah, and also potentially space in that CME, space, in terms of like thinking about how we deliver that successfully with our mana whenua aspirations and with their partners. Yeah. Yeah.
Thanks, Jan. No.
Kia ora, Livia. Thank you again for well-articulated first part of this. You actually, I'm going to, later on, Craig, can we then have a general overview of the whole thing? So specifically, you were talking about cost recovery. And I mean, looking at it, how do you think, like you said that it probably will be more beneficial, for the territorial authorities actually to, when this new thing comes in. I'm just wondering, because one of the big issues that have been around is actually the cost recovery for iwi involvement and, actual and reasonable costs of iwi involvement. I mean, there's the Section 36, which actually ties all that together. Can you see that this may actually lead to either a better tool for the cost recovery from iwi?
It's hard to know. I would say that the changes that have come through here for cost recovery are very narrow and targeted. So it's around sort of incident and complaint response and that permitted activity monitoring. So unless we'd have to look at those provisions and see what opportunity there might be there, but there's not a broad ability to cost recover. And we do have a restriction around even what type of rules we might be able to cost recover for. It does help lessen the impact potentially on the ratepayer for some of this work. But yeah, I probably can't give you much more than that at the moment, I don't think. Yeah.
Thank you. I'll look forward to the second part and then have a comment about it, because I was at a meeting at Tuahiwi about this and I nearly got strung up in some ways just because one of my look at it, I thought that it's coming towards being more balanced actually, but I'll come to that later.
Thanks, Nick. Peter? No, I'm good. Oh, you're good? Ian?
So in terms of the use of past compliance history, the way I read the documents is that that's for significant. And so things like not posting your consent up on your cowshed wall and things like that won't count, which is a high proportion of our non-compliance activities, isn't it? Yeah.
Correct, and James will talk about that a little bit when we come to it, but you're correct, significant, ongoing, repeated non-compliance, and it relates to specific actions and enforcement action. Yeah.
So although, I mean, it's the right incentive to improve behaviour, it's not a critical threat except for the delinquents, yeah.
Cool. Let's carry on then, I think.
Kia ora, councillors. So I'll cover off the consenting aspects. I guess I actually, having looked at the slide just now, I think there's probably a third thing with there's sort of three limbs to the consenting changes. The first is around improving the efficiency and speed of the system. The second is around improving that certainty, I'd suggest for certain consent applicants, because it's not all of them. And the third is around those links into the new CME components that James will talk about. While the Act came into effect on the 21st of August, most of these changes come in on the 21st of October, so there is a bit of a lead in time. The ones that don't are, as Councillor McKenzie just indicated, the ties to looking at applicants' compliance history. A 35-year duration for renewable energy and long-lived infrastructure, and an ability to decline some land use consents on the basis of natural hazards risk. Of those, the first two are the ones that will have the greatest impact for Environment Canterbury. The land use ability to decline land use consents doesn't include infrastructure and it doesn't include primary production. So it's very much going to be more in a territorial authority space. Of the provisions that come in later in October, those are more aimed at the streamlining of the system. And that includes both for the council and for applicants. So part of the changes are around, if you like, right-sizing applications. They're aimed at making sure, and it's already built into the Act, but it's more explicit around that the assessments that the council receives are appropriate for the scale and significance of the activity that is being undertaken or proposed to be undertaken. Along with that then comes additional considerations for when the council requests further information, being it has to be appropriate for the scale and significance, and also that it has to relate to making a substantive decision, which does raise some questions around how that might then influence notification, questions that would more directly relate to notification criteria. And we're working through that at the moment because there's could be some unanticipated consequences of that if we just have to make notification decisions based on the information we receive and can't ask for further information about those aspects. The third thing, which is it would have been great for us to have last year when we were working on our backlog, is the ability to return abandoned applications, is how it's been described. That basically relates to where the council has requested something or the applicant has told us they will do something by a particular date and that hasn't happened. At that point, we can write to the applicant and say, hey, you've missed your date. If we don't hear from you within a certain time period, we will return your application. That actually applies retrospectively to applications we already have in process, but doesn't take effect until the 21st of October. And there's a split time frame for that, which is for any application received before the 21st of October, they've got if you like, a year's grace. So if the date was today, they'd get a year from today, and then we could return the application. For anything after the 21st of activity, it's for the 21st of October, it's 3 months. So again, there's that differentiation to allow applicants and the public to get their head around what these new provisions mean. The changes around the consideration of compliance history, as Councillor Mackenzie noted, are very much around where we have used our formal CME tools. So that's abatement notices, infringements, enforcement orders and prosecutions. Applicants are going to need to declare where they've been subject of one of those matters when they apply. And interestingly, it appears to apply, across jurisdictions. So it's if a company comes down to Canterbury from elsewhere in the country, they bring their compliance history with them. And they'll have to declare that to us when they make those applications. The last thing on there is around the reduced costs and improved clarity for consent applicants. Part of that I sort of touched on with the new restrictions for further information requests, but there's also increased certainty, particularly for large infrastructure, with a default 35-year duration for renewable energy and particular specified infrastructure, long-lived infrastructure projects. And sorry, I've just lost my train of thought. Let me just check my notes. Oh, and a 1-year processing time for some activities, including specified infrastructure. Again, that's significant major infrastructure, as you would expect, electricity and things like that, and for wood processing activities as well, so sawmills and the like. In terms of implementation, we've already started meeting with our Tangata Whenua Advisory Services, our Papatūārangi environmental entities, to discuss the changes. We've already met with Mahanui Kuatao and Aoraki Environmental Consultancy, and I understand that staff are meeting with Okaha tomorrow to discuss these changes and what the implications are going forward and how we work on those. We're also working on internal guidance on how we take these new tests into account, because we'll actually have to record that we've done this thinking when we make them. It's an additional administrative step, because otherwise we can be challenged on these things, which I think is covered off on the next slide. And also talking with James and his team around what is considered significant, a history of significant non-compliance, so that we can be consistent in how we do that. And we're also talking to our colleagues at other councils to make sure that we're aligned as possible across the sector, noting we all have individual peculiarities between us. And then finally, we're producing guidance for our practitioners, updating our forms and processes. We've already updated our application form and should hopefully be up on our website with the updates soon. So typically when we receive or when RMA changes come in, that has a bit of an influence on our community as these things start to be socialised. Typically we see a sort of a spike in applications as everyone sort of rushes to get applications in the door before new powers take effect, if those powers are the councils. In this instance, we've sort of emphasised that we might see that because in this case, the powers that are most likely to impact on new applicants are the ones that have already taken effect, being those ones around the compliance history. As I sort of pointed out, we've got new administrative considerations we need to take into account in terms of when we receipt applications and also in terms of when we request further information, and that might see some more challenges as we work out where the balance of those is. And then with this default duration around long-lived infrastructure and renewable energy, that could result in some concern from some parts of our community around those very long duration consents and locking in those activities for significant periods of time.
Thank you, Phil. Thank you, councillors. So the impacts on compliance enforcement are really into some really broad areas. It's probably best to discuss. There's been an increase in the fines. These haven't, in the case of infringement notices, they haven't changed since 1991, so they were probably brought into line. Some of the stuff's going to make prosecutions a bit easier for us, a bit more streamlined. We've touched on charging for permit activity monitoring and instant response. And it's going to simplify some technical issues with infringement notices and abatement notices. The increases in the infringement notice penalties, as I said, haven't been changed since 1991. They're generally doubling for individuals and they're doubling again for companies. So, for example, the industrial activity one was 1,000. It will now be 2,000 for an individual and 4,000 for a company, which makes them what they were always intended to be, which was a bit more than a minor fine, but not a prosecution level. Whereas we found with some of the things, it's been you issue someone $1,000 fine, and it's $1,000 is $1,000, but for a big corporation, it's they're always meant to be intended as a quick fine. There's now prohibition on insurance for infringement fines and for prosecutions. So that's come into effect now. We've already had a case in the court where someone realised that was advised that was the case by their legal counsel and changed to a guilty plea early on because they realised they wouldn't have to cover the cost themselves. So that's already having an impact. Increase in the maximum fines, they've gone up significantly to $1 million for an individual and $10 million for a company. Those are the maximum fines available. That's they've gone up significantly. We won't be seeing the fines going up pro rata for the next case we've got, as normally happens in prosecution cases. They gradually ramp up. We've talked about the declaring compliance history. Now, to answer Councillor Mackenzie's question about significant non-compliance, as a consent holder, you will know that you wouldn't because your consents aren't non-compliant. But significant non-compliance is a grade we put on a resource consent against a condition. What this means is when we take an enforcement action, which the person we take the action against has the right of appeal. So it has to be something that the individual can appeal against. So that makes it abatement notices, infringement notices, enforcement orders and prosecutions. So those are the four things that are taken into consideration as significant non-complying. not a grading on a consent condition. Even if we grade it as significantly non-compliant, if we don't do an abatement notice and infringement notice, it doesn't count. And I think that's fair because it's the right of appeal, the right to have it listened to and heard and accounted. Enforcement orders can be sought from the Environment Court to revoke or suspend consents for serious non-compliance. That's the top end of the scale. So the level of proof and the level of significant ongoing non-compliance has to be quite significant there. The change in the maximum prison term from 2 years to 18 months is there to knock out the option for trial by jury because some of these things can be very technical and complicated. So hearing it with just for the judge is going to make things probably easier. And there's a single word changing in the abatement notice provisions for what we call a to-do abatement notice, which is now it doesn't have to be. It can be just for a breach of a consent condition. So we can require someone with an abatement notice to comply with a consent condition, whereas previously it was and where there's an adverse environmental effect can be proven. And we've actually just dealt with one of those about 45 minutes ago before I came down. So these things are happening now. What we've done to date, as I said, we've seen some of these things take effect already. We have our systems are in place already for infringement notices, so we've now got a parallel database running for the new fines because it's from 4th of September, so it's only for offences that happened from tomorrow onwards. So we're still dealing with stuff that's happened 4 months ago. So if an offence happened prior to the 4th of September, it's dealt with under the old system and the old fining regime. So we have to keep that system running. And then when we come for events that occur after 4th of September, so from tomorrow onwards, we'll be using the new system. We've spoken to the staff quite extensively on this. MFE ran a fantastic webinar yesterday, which a bunch of our staff attended with senior staff there to talk them through it. The guidelines for abatement notices and infringement notices and prosecutions, we're looking at where we're going there, how we sit with our enforcement decision panel. I would anticipate that we might get more appeals against infringement notices, abatement notices, because they now count as a significant non-compliance. So we might get people pushing back on those a bit more. We're fairly comfortable in the robustness of our process for those, so we're quite comfortable with that. And as I said, the databases are up to date. And this is working in with the Smart Enabling Regulator program we're working on. So we're feeding into that as well to make sure they know. I think I've covered everything on there, really.
Thanks, James. I mean, we can raise questions as well. So I think, did you have a question? Then I'll go to you, Peter. Please.
Yeah, just on the enforcement and particularly the fines, what is the formula? Is there any kind of formula? Because obviously, if someone has really damaged the environment, like wiped out an area of Mahinga Kai, for instance, which actually takes a long time, years to actually remediate it and bring it back. Is that the kind of thing that they base the formula on, as an example?
So the fines for a prosecution case is set by the judge, obviously, but the judge will look at the Solicitor General guidelines on prosecution, and those sorts of things are taken into consideration in previous history. Adverse effect and Mahinga Kai sites are specifically mentioned in there. Yeah, but if the infringement notice fines are just set, and they are based on the section of the Act which is breach, and they're set in stone. The fine levels there.
Sorry, just one supplementary. What about serial? Is there such a thing as a sort of a serial offender? And what happens?
Yes, absolutely, and that's considered. Again, the Solicitor General guideline talks about that in terms of repeat non-compliance and failure to act on previous advice and actions, and that would be something where that is our enforcement decision panel that sits when we discuss whether something is an infringement notice level or a prosecution level. We go through those systems to say which one of these are applicable. Yeah, absolutely.
Thanks, James.
Sorry, can I just add? I'll just add to that.
The new provisions for consenting is also based on that, a sort of a recidivist offender, and that has now given us the ability to decline consents on the basis of someone's compliance history if they have that history of significant non-compliance. We won't give it to you again.
And can it go further? And so that particular person or company can never, ever apply for a consents again?
We can't stop them applying. For natural people, so actual humans, there's a 7-year sort of statute of limitations. For companies, it seems to be unlimited. So a company who does something wrong and they keep doing the same thing over and over again, then you can go, well, no, we're not going to give you consents again.
Peter.
Essentially, you've answered the question, because I was thinking of non-compliance abatement notices and continued breaches or your consent conditions actually affect your credit rating in terms of when you come to reapply. So that's fine, but the continued activity. I mean, we tend to, when we take people to court, we tend to get beaten up. What's the bottom line then? Where do you go to from then? How's it enforceable beyond the fact that no one's going to listen to us and you're going to fine them $1,000 a day and they're making $5,000? I mean, where's the bottom of the cliff?
So when we did some work a few years ago against a mining company in the region, and I think we issued 24 infringement notices for a whole bunch of offences, and the judge didn't take kindly to that, because he was of the opinion that if you're at that level, you should be prosecuting. So if we would be, an infringement notice is really there as a shot across the bows. It's like, it's $4,000 now for a company. Here's a fine of $4,000. Don't do it again. This is a warning. And then the next time it comes around, we take into consideration the history and the deliberateness and the impacts, and a whole bunch of different things that are in the Solicitor General Guidelines, which I'm sure you will know about. But when we make that decision as to, is this just an infringement notice or a abatement notice, or is this a prosecution, we would consider those things absolutely. And repeated ongoing non-compliance is definitely there. It's a point where you go, right, okay, we can't, there's no point issuing infringement notices anymore. And just to clarify one point, the significant non-compliance isn't compliance history with your compliance monitoring reports. That's not counted as significant non-compliance. Even if you get a consent condition graded significant non-compliance, that's just a wording thing. It's just abatement notices, infringement notices, enforcement orders and prosecutions.
Cool. Thank you. Claire?
You might have just answered the question, and it goes back to the consideration of the past history. You just mentioned 7 years. So is that the limit for most applicants that would be here? You would only...
Yeah, I think it's like points on your driving licence. After a while, they drop off. And for natural people, that's 7 years. So if you've had a prosecution against you and that was 7 years ago, and then you come to apply, Phil can't take that into consideration because it's dropped off the radar. But for companies, it seems to be it's in perpetuity.
Just with regard to applicants declaring compliance history, is it only the compliance history, for example, on that block of land or for that activity, or?
Sorry, Councillor McKay, I cut you off. No, from what we can tell, it's your compliance history follows you. So if someone comes from, I don't know, moved up from Southland, they bring their compliance history with them, which is why the declaration is quite important, because obviously we won't have access to Southland or Northland or whoever's systems.
John?
I think my question's been answered. It was around, you've lost the word, significance of when it comes to reapplying. So it's abatement notice, fine, or whatever is deemed significant, and then you will look at how many of them, what they are, as opposed to just a singular event or event here and something there.
It's just those things where there's a formal right of appeal against that action that we've taken. So you can formally appeal an abatement notice and an infringement notice and an enforcement order and a prosecution, obviously. If we monitor a consent condition and say this is significantly non-compliant, blah, 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 please do these things, the consent holder hasn't got a formal right to appeal that, so that can't be considered as against them in terms of compliance history.
Dion?
Thank you. I've got a couple of questions. The automatic exemptions and the intensification provisions, does that mean airport contour lines, or is that something separate?
Wish I could give you the detail on that. It relates to sort of intensification of housing provisions or urban development from memory, and I'm not sure if it covers the airport contour lines.
Yeah, I would actually quite like to understand that at some stage, because airport contour lines will enable urban development and enable will help the minister and Christchurch City Council to meet their MDRS obligations. Rule 5.63, the elevated, has that been elevated to the Audit and Risk Committee? Because that's a massive risk to scale up of the organisation, and if need be. And I haven't heard anything.
As far as I know, no, it hasn't. But I'll take that back to check on it. I'm not familiar at the moment with the process when we have court proceedings and how that comes up to the audit and risk committees, but we'll take that back with us.
Yeah, because I was just noted down the scalability. If we need to scale very quickly, we need to understand how we may need to do that. How are we communicating the constraints with communities, especially in the time at the moment where we need confidence in regional government? And all of the other narrative feels like we're getting really constrained in what we can do. So what are we doing to communicate these changes so that we can say, look, this is the changes, this is how we're addressing it, rather than sort of like being the victim in this whole changes?
I guess we're using, and it comes a little bit to the last slide around the sort of implementation update and next steps, we're tending to use our traditional sort of communication channels. So we use things like media statements, we use our communication channels through our practitioners and our consultant groups. We do a lot of work through Te Uru Kahika to socialise that internally, but that's not out to our communities. But there is also a role for the ministry here, noticing that the ministry has a role to play to socialise this. So we're using our things like Rural Matters, that's one of our streams, and effectively sort of raising the profile of the changes through our website and things like this briefing, to be honest, making sure that this is visible so people are aware of the impact of the changes. If we think there are other things that we can do or other channels, then we can look at those as part of our communications plan.
Yeah, I think there might be something in just, we heard around the from the young farmers, rather than the broadcast out other means of engagement and engaging these changes. The only other question, and I don't know, and I actually probably no time to answer it now, but I hear we're going to have a briefing around the Smart Enabling Regulator program. What I'm reading from the EAG report and hearing and seeing from what's going on and conversations that I'm having is around the compliance space, especially, whether we're heading in the right direction and whether we're sort of spending money in the right places at the right time. So think about that, and I just wanted to ask that question for when that comes. And I appreciate we're running out of time, so we can leave it for the next one. But I've got my eye on that because I'm worried we're not potentially going in the right space in the right direction.
Okay, last one, Grant.
Yeah, thanks for this. Just on page 21, this issue of developing criteria as a guide for decisions about scale and significance. Is there a time frame for you for the need to is there a time frame for you to actually deliver on?
So those provisions take effect on the 21st of October. Scale and significance is already in the Act. It's just buried in Schedule 4, which is what needs to be in a consent application, and it already mentions it. What these amendments have done is pretty much have dragged it into the primary section, so it's almost front and centre. Scale and significance is always that case-by-case assessment, but you're sort of guided by case law and there's sort of aspects in terms of, trying to determine whether it's appropriate or not.
The other issue in terms of large-scale infrastructure projects and those sorts of things, is Crown property and the actions of the Crown also covered by these abatement notices, infringement notices?
It's all right if you don't know. Like if you don't know,
We're both looking at each other, scratching our heads, which means we don't know, but we can find out for you.
Yeah, but good question, Grant. We could hopefully go away and find that out and bring that back to us.
What I would say on that is we do know that under various other legislation, the Crown is often protected or insulated from things. I'm just not quite sure on this instance. Yeah.
Thank you. Well, that would be one example. Yeah, I think, Dion. But good question. Hey, thank you so much, team. I mean, there are some good things in these changes, especially around the compliance space and the fines, infringements. I think that's been well put. And obviously, as Yayan mentioned, sort of the concerning things for us that you've highlighted around the ministerial powers, and especially the one that would direct us to make changes if we hadn't budgeted that for that in a long-term plan or an annual plan like that. Is quite concerning. It should be concerning for everybody. So because that's massive, unless the law would actually come with the funding to go with it, but I doubt that's the case. So yeah, some concerning things about that overreach in terms of our powers and our ability to work with our communities, but some good things as well. So thank you for bringing these to us, and thank you. Oh, did you have a question?
It was really just an observation. Just around the mana whenua perspective, particularly after being at the meeting at Tuahiwi. So when we look at this, the whole kind of legislative changes and actually what the work that you guys have done to date, one of the key things out of this for me is that and I thank you for it actually, is the consultation engagement with mana whenua and Papatupa Runanga. The really interesting thing is that there is sort of people out there that deep concerns about treaty undermining, calls for rights affirmation, but it's mixed optimism in some ways, because when you look at the the graded permitted activity, so they're saying there's few touch points, for consenting. The other one was the fast track approvals, bypassing Māori involvement. But when you look at the other side of it, there's the Spatial Planning Act, which strengthens Māori input. There's natural and built environment as well. And so what this does is kind of more formal roles actually inside these sort of committees. So I don't know whether, I feel that it's actually shifted from a bit of ad hoc where Māori are concerned, and it seems to be a lot more kind of structured in that kind of decision making. So that's what I kind of said at this meeting at Tuahiwi, and people later, they actually started to come around because there's a lot of rhetoric out there around this. But I just think that this work that you're doing is really going to bring the Papatupu closer, to our kind of Environment Canterbury staff, because everyone's fearing all this change. And it's actually, in the end at Tuahiwi, they actually said that it was really good because they can rely, and yet, we've got the Rōputuria situation, all of that. But at least the general consensus is that they think now that it's actually better to stay and work with ECAN because you guys are actually understanding more and communicating those changes to Papatupa Runanga. Kia ora, thank you.
Thanks, Nick. Let's finish off. Who started this morning? I didn't, but it wasn't me. But Grant, are you happy?
Yep. Anuhia, ki te uru, tapanui o tāne, kia watia, kia mama, tēnā kau, te tinana, te wairua, I te aria, tākata, koia e ronga, whakaria, aki I runga, kia tina,
Ina.
umiai, huiai.
Kia ora, Grant. Thank you. Thanks, everybody.